number 10, the people of the state of New York versus Ramlall. Good afternoon, counsel.
Good afternoon. May it please the court, Natalie Ray of the Eagle Eight Society for Mr. Ramlall. If I may reserve 2 minutes for rebuttal, please.
Yes, you may.
The question here is whether the 971-day delay.
Counsel, looking at that delay, is the question for us to apply the Taranovich factors here and just do the standard Taranovich analysis that the court would do, and now this court's going to do, based on what I think you're about to recount as a very long and tortured history regarding a traffic infraction. That's what we are going to do here, right?
I believe so, and I think that the Taranovich factors and your clarification of them in Wiggins apparently are worth repeating, because we go on.
So let me ask you this. You would agree then that, based on the majority writing in Wiggins, that the problem of prosecutorial readiness addressed by CPL 3030 and the constitutional speedy trial right are not analogous?
Absolutely. They're not.
Right? So they're not.
No.
So we're not going to be looking at all that calculation that went into the 3030 time for the misdemeanors that got dismissed.
No, the way those computations were made don't apply to 3020, but the delays that took place between the complaint and the 3030 dismissal count, which the people are no longer counting. They were, I believe, 200.
So let's look at the factors, if we can, for a second.
Yes.
The second factor, would you measure it in relative terms or absolute terms? In other words, are the people, is their contribution and, to the extent that they are responsible for the delay, is there some sort of, relative balancing, because some of these requests were made by the defendant, some were,
I think that
court congestion. I mean, how do we look at that second factor?
I think that this court and the Supreme Court have kind of said, if there's real, that court congestion may not be as as weighty as, kind of really bad faith by the people, but good faith.
So is there any really bad faith here?
But good faith doesn't excuse the people. I don't know if it's bad faith, but there is some very serious negligence, and I would let the court decide whether it's bad faith or not. But when they were ordered to provide discovery on June 8th, 2012, and they satisfy part of it in October, and they fully satisfy the request in May of 2013, I will say it's grossly negligent. They sat on that information, but it all counts. They're not.
Is that also a factor in if we're to look at the fact that obviously there were numerous requests for adjournments by the defendant here? So does the fact that some of those may have been necessitated by the lacking discovery, is that something that factors into the analysis?
Well, I think yes, of course it should. But even if you didn't, I have counted that there were 771 days that had nothing to do with the defendant. And even in being generous and saying, maybe.
Well, how does it factor in that somehow, whenever the people were ready, the defendant never was?
That I don't think never is the issue. When the people ask
I mean,
for...
I agree that it's never an issue under a 3030 analysis, because a 3030 analysis is about the prosecutor's obligation. But we're not talking about 30-30.
We're not, but we are talking about the prosecution's burden. They bring the charge, they have to bring it in a speedy manner. And when they're asking for 2 days, and the court says, okay, let's give it 3, and we say we'd like a little more time, and then the adjournment is 50 days, let's say, the prosecutor never objected, which the prosecutor did in Wiggins. In Wiggins, the prosecutor started thinking, oh, wait a second, there's a little too much delay here. Here, our position is also, once the 30-30 was granted, everybody should have been on notice that this case, there was delay. And the court has also an obligation to make sure to maintain the confidence of the people in not having cases last 2.5 years.
So, well, that problem's going to be solved going forward because of the amendment of the statute, so we won't have that issue. We'll be able to clear these out when we clear out the misdemeanors. But if we're looking at all these factors and you want us to clarify factors, let's talk about the third factor for a minute, which goes to the nature of the offense. What do you think that means as we've articulated it in the past and as it applied here? Is it the fact that it's just an infraction, or is it, as some of the decisions I think have talked about in this case, the fact that it's a drunk driving case and people are concerned about drunk driving? Is that what serious means? What does it mean?
Well, I think that the court here has made it clear that it's not simply the serious, like it's a murder or it's a misdemeanor. That's not the end of the conversation. The right to a speedy trial takes into account the complexity of the case. So if this were an incredibly complicated DWAY case, maybe you could have more time. But the highly relevant factor.
So here, sticking with that, because there was a blow here, right? I know that he's not being prosecuted based on that statute because that got dismissed. But if they wanted to introduce that evidence to prove the DWAI, don't you have to get all the calibration records and all of that in order to lay the foundation to get those readings in?
What I don't, and they were
complex,
and there were there were extreme delays in providing that information to the defense, and I don't think that's you could say it's complex, but if that is a level of complexity, then it could be taken into account. It still doesn't excuse.
Did the prosecutor ever raise those concerns?
Of getting.
Did the prosecutor ever raise those concerns? That it needed time, given the complexity, given the needs, as Judge Feynman has described them?
No. And one day when they were ready for the hearing, for the machine, they were not ready for that. So it's complex, but it's not complex in the sense that it's a very important, complex prosecution. So as in Wiggins, if in Wiggins, where the defendant was facing life, 5.5 years delay is too much. In this case, where my client is facing 15 days, 2.5 years is really excessive, and the seriousness of the crime that factor can't weigh, or maybe you want to weigh it less than I do in favor of the people.
Given the fact that he was not incarcerated, what do we have to look at to determine whether he was prejudiced?
Well, I think that the prejudice, I think these are two separate, two separate factors. I mean, they can go together when there is incarceration,
well, that's
obviously.
often part of the prejudice.
It is.
Absent that, what I'm saying is, what do we look to for?
Well, I think you've said in previous cases what to look for.
What do we look for here? What is there in the record here?
Here there's, in this weird world we were in before, where here you have the 30-30, the misdemeanors were dismissed. The idea that this survives seems to be a bit of a prejudice. Part of the prejudice. The 971 days may be the kind of length.
971 or 917?
971, I believe.
Okay.
But I'm not, I think that, it's 971.
Whatever it is, it's more than 900.
It's over 950.
What if he only had to make 5 appearances within that whole time, and he was otherwise going along with his life?
Except that he made 29 appearances, Your Honor.
Well,
29.
did you ever request to have him excused?
Excuse me?
Did the defendant ever request to have his
Yes,
appearance
and
excused?
the
I mean, there
only-
were times where he
And the
was.
only time he asked to waive his presence, the court said no. And the only time in 29 times where he came in late, an hour and a half late, out of 29 sessions, when the DA kept arriving and saying they're not prepared, the one time the district attorney didn't keep their client, their witness there, and there was a 30-day delay. He came in 29 times. That's 6 weeks of work for a person of very little means. This is an incredible, it is prejudice, and it's part of the prejudice analysis. So if you put the 971 days, or I say presume the 33rd dismissal of the greater charges, and on his person, I think we've established that.
Thank you,
I'll
counsel.
keep-
Thank you. Counsel?
Good afternoon. My name is Ann Bordley, and I represent the respondent, the people of the state of New York. Defendant's claim should be rejected for 2 reasons. First, the Sixth Amendment right to a speedy trial should not apply to traffic infractions. The Supreme Court has indicated that the Sixth Amendment privileges do not apply in all cases. For example, the Sixth Amendment right to a jury trial does not apply to petty offenses, which are defined as offenses for which you can get 6 months or less. And in this case, applying the right to a speedy trial to a traffic infraction doesn't serve the primary purposes of the Sixth Amendment right. The primary purpose of this right is to prevent oppressive pretrial
Doesn't it
incarceration.
seem odd to you that, we're using the fact that it's a traffic infraction and require the person to come back, over 2.5 years, 29 times?
I think it's a concerning fact, but I don't think that goes to the question about whether it's a constitutional violation. I think that's a separate question, but we concede it was an extremely long time.
Right, so let's say the court takes the view, well, you know what, we don't really need to decide whether it's a constitutional violation.
Very well, then.
Then what?
Well, then, we'd argue that the trial court in the appellate term correctly concluded that applying the Tranavich factors, there wasn't a violation. Now, unquestionably, there was a very long delay in this case, but a significant portion of this delay was attributable to the defense. In the beginning of the case, the people did not answer promptly the first speedy trial motion, and that was ultimately, generally speaking, the cause of the dismissal of the misdemeanor counts. But at that point, we started announcing ready. In fact, we announced ready the next 3 times. After the dismissal of the misdemeanor counts, we in fact announced ready on 10 different occasions. 7 of those occasions, the defense requested the
What point did you
adjournment.
comply with all of the discovery requirements?
We actually provided some discovery from
No,
at the
but when
arraignment.
did you completely comply with all the discovery
It-
requirements?
There was an accident report that we did not get until very late, and we turned it over as soon as we got it, but that was shortly before the suppression hearing. That was late. But the assistant attorney said, here's this accident report I didn't even know existed, and I'm providing it now, because this is the first I've seen or heard of it. We provided other discovery much earlier.
I guess the question is, given all of the factors, why should things like that fall on the shoulders of the defendant?
Well, I think you have to consider the Tranavich factors. I think you have to consider that there's at least portions of this delay are attributable to the defense, and the Supreme Court has said those are considered waived for purposes of this issue. I think you can also take into account that the trial court thought that the defense was trying to sort of engineer a speedy trial dismissal. They thought that their claims of prejudice were wrong, and it is kind of interesting. So after the speedy trial, the 30-30 dismissal of the misdemeanor counts, then we come into court and we announce we're ready several times. And the first time the defense attorney is saying, well, I need an adjournment because I haven't gotten the medical records yet, and because I want to get the fire department file. And then they get the fire department file. And after that, they start asking for an adjournment for these witnesses, right? And this is on August.
Let me ask this on that issue.
Yeah.
Did the court offer to sign a subpoena to
Yes, they did. They said,
explain that to the court? Explain what was going on there.
well, the defense was saying they said that the fire department had been very helpful. At a certain point, they said the fire department's been very helpful, but they did not, won't give us her home address.
Mm-hmm.
And so the trial court was immediately like, oh, that's fine. Oh, I'll be quite happy to sign a subpoena ordering the fire department to give you the home address so you can serve a subpoena and get this case moving.
Was that ever done?
No, not as far as we can tell. They never actually did serve subpoena. And
I have a question on this issue of the subpoena. I don't know how it is in Brooklyn, but it used to be that there was just a basket in every AP part, and the defense counsel would just drop their subpoenas in there to be signed by the judge, and then you pick them up at the end of the day. Is that...
That did not happen here. And again, they started at, it wasn't clear exactly until their speedy trial motion when they explained that they were looking for these 2 EMTs. But they were looking as early as August 13th to try to find these witnesses. And that's like 14 months until the speedy trial motion that they're either asking for an adjournment because they're looking for them or because they're trying to subpoena them. And so they weren't seriously trying to get a speedy trial. They were trying to get a speedy trial dismissal here. But in addition, there's the other factors. Defendant was not incarcerated pre-trial for a very long time. Defendant was released on the day of his arraignment in criminal court. There is the seriousness of this crime. This court has always considered driving while intoxicated to be a serious offense. And while
But isn't it about the complexity of cases? Since we're talking about how long you have to bring a case to trial, isn't the seriousness of the case really about how long it takes to prepare the case for trial?
I think you can consider the complexity of the case. And actually, I think driving while intoxicated cases can be actually kind of complicated because you have to have
But you announced ready at arraignment, didn't you?
Correct, because usually at that point, when everything is new and fresh and your officers are all available, you can be ready very early on the case. But then things happen and you lose some of your witnesses and you have to substitute other witnesses.
Did you raise any of those problems?
In our answer to the 3030 motion?
Yeah.
No, I don't think we did.
30-30 or the 30-20?
I don't think it would have been relevant for the 3030.
Right, no, but you said 30-30, that's
I'm
why I
sorry.
was just making it clear.
Oh, I apologize. But to get back to your question, I do sometimes think the complexity counts, but I also sometimes think seriousness of the crime counts. Sometimes there are some murder cases that are very simple, that are really simple, but we still get lots of time for murder cases because of the seriousness of the crime and society's interest in making sure we get a correct result.
The seriousness factor is just not limited to any one issue.
Correct.
Is what you're saying.
Yeah.
It seems like this case is almost a straightforward comparison to Wiggins. We have Wiggins where a long period of jail time, and it was alleged that the jail time was being coerced to use the defendant in a particular way that the defendant wasn't agreeing to be used for. And the comparison here seems to be more to incompetence than an attempt to force a particular testimony out of a defendant. Does that weigh into this at all? I guess how much
yes.
incompetence crosses the line to become actual prejudice?
Well, I would think there's some explanations to be made about some of the...
Well, there always are, but
No, but-
any way you cut it, I think about half this time at a minimum, maybe about 60% has to count against you. So there's a fair amount of incompetence.
But I would draw your court's attention that there was the arresting officer who was a necessary witness in this case suffered a line of duty injury.
No,
And
but
there
that's
goes-
not my question. My question is for the Taranovich factors to apply, which they did in Wiggins, there seems to be underlying policy reasons there. And here, do those same policy reasons apply? The policy reasons of using incarceration as a coercive means to force particular testimony, that actual prejudice resulted in doing that. Do we have that here?
No, Your Honor, I don't think we do.
There's no bad faith here
Right.
by the prosecution. is
No,
there?
Your Honor. No, Your Honor.
And it would be an extraordinary holding, would it not, to say that any negligence, assuming there is negligence, which I'm not saying there is, in complying with discovery obligations, now is tantamount and equal to bad faith.
Or a
That would be an
constitutional
extraordinary
violation.
holding,
even.
wouldn't it?
Yeah. I'd see what the judge saying, even a constitutional violation. Well, opposing counsel can address that question too when she gets up, so we'll let her do that.
In any case, to get back to where I started, which
Yes.
is, given that a significant part of the delay is not on the shoulders of the defendant,
Yes.
why then should this extremely long delay, which even you concede, for this kind of a charge, which does carry 15 days potential of incarceration, should fall on the defendant?
Because there was no pretrial incarceration, which is one of the primary
Given that the
reasons.
misdemeanor, of course, is already dismissed as excessively delayed.
Yeah, under 3030, which is a readiness
Yes.
rule, but not
No,
a
I know that.
constitutional speedy trial rule.
I know that.
because
But there
of
is
the-
something to be said about that, do you not think?
Yes, but-
Of course, I understand the point. We're talking about a statutory violation versus a constitutional violation. But the statutory violation can certainly inform the analysis of the constitutional violation.
I'm not sure it is as significant for the constitutional speedy trial violation. At one
Well,
point,
whether it's significant, the weight of that significance is not my question. The question is whether or not it is something for consideration. You may argue that it should not weigh against you, but to argue that we should be blind to it, I'm very troubled by that position from the people.
I'm not saying that we are blind to it, and in fact, after those counts were dismissed, I think we tried very hard to be ready, and then the arresting officer got injured in the line of duty, and delays resulted. But I don't think, to the extent that the defense has suggested, that the prejudice prong is influenced by a 3030 dismissal. I would think that's incorrect, because it's a national rule, and nobody else is going to be governed by our 3030 statute, and because prejudice isn't part of 3030, it's not even a consideration of 3030. So you can have 3030 dismissals where the defense is not prejudiced at all.
But we've also said you can assume prejudice under the circumstances. So again, what has happened that results in the 3030 dismissal may be of some concern in the
But-
constitutional analysis. And I don't really understand why the people reject that what I think
It
is
could be-
a very moderated way of thinking about it.
I think if you're in Kansas and a defense attorney says you have to consider the fact that they violated 3030 under New York law.
I'm not talking about Kansas. I'm
But-
talking about New York City and whether or not it's a constitutional violation given the way the case and the prosecution unfolds.
But the constitutional speedy trial right has to be the same in Kansas as it is in New York City.
Yes, but all I'm saying is under the 3030, you're already identifying numerous delays that fall on the prosecution. And the clock starts, not from the 3030 motion, of course, although I understand
Yeah.
some of that argument. It
Yeah.
starts from day one.
Yes, yes.
But isn't the answer there really to the extent that anything you've considered in the 3030 motion applies to the constitutional analysis, it's relevant? Under a general constitutional analysis, if it's relevant and it was relevant then, you could look at that. If it's not, it's not.
But
And
ultimately,
it seems the legislature made a deliberate determination at that time that these weren't subject to 3030.
yes. And given all of the circumstances and considering all of the Tranovich factors, the trial court in this case was correct to conclude that there wasn't a constitutional speedy trial violation, even though the court had concluded that there had been a 3030 violation earlier in the case.
Thank you, counsel.
Just a few points. One is the substantial delay caused by the defendant amounts to 196 days out of these 971 days. And I agree that those should not count in the delay. As far as the policy,
Shouldn't we try to look at it a little more holistically? I mean, you, I think, started out by saying we're not really in the counting days mode. And I have sort of, less than a year from the car crash, 4 back-to-back times when the people say we're ready, May 2nd, June 10th, July 11th, August 1st, and the defendant says he's not ready. And there are then, a few more times not long after that, still in the year 2013, where the same thing happens.
and yes, but when they say they're not, in the holistic approach, when they say, for example, on November 20th, that the people want 2 days, and the
No, I'm not
defense
there.
says,
I'm not up to November 20th. I'm still back in May and June and July.
of 2012.
2013. No, May of 2012 is when the incident happens.
I have a very handy little chart.
So do I.
So do I.
I think everybody's got a
we all.
chart.
We all do. Mine is,
may not
mine
have
has
yours.
colors.
Mine does too.
Not coincide with yours.
There's no question that we were responsible for some time. And the thing is,
I'm trying to ask you something a little different, which is, aren't you saying we should get away from the just counting days and try to look at what happened here as something organic? And at least to me, there's a portion of time here that's within a year or just after a year of the incident, of the arrest, when the people are ready, and your client is not.
And yes, and maybe we should get away from some of the days, but
Doesn't that count a little bit more heavily than just the number of days associated with those 4 events?
except that the delay of the defense is caused by the people who never provided discovery for over a year. So if we look at it in a holistic way, it becomes more difficult to weigh. It also becomes, unlike Wiggins, where the prosecution objected when the court said, let's adjourn for 30 days. Here, there never was.
So on May 2nd of 2013, what was the discovery that you had previously asked for that you hadn't received by that point of time?
Excuse me, which date did you go?
May 2nd of 2013.
Okay, May 2nd, 2013. By then, that day, they produced the 911 tape. That day. Therefore, from there, we identified some witnesses, and then we caused some delay, and I could see.
Then on that day, you asked for an adjournment till July 11th.
Yes,
And the court didn't give you that, it gave you June 10th. And
yes,
you were not ready then, even though the people were.
yes, Your Honor,
Yes.
yeah,
Yep,
absolutely.
okay. And then you got the July 11th, which is what you'd asked for before. The people were again ready, and you weren't.
Yes,
And you asked for an adjournment to August 1st, you got one till August 1st. People were ready again, and you weren't, and you asked for September 24th.
yep.
Was there discovery missing during that period?
We were trying to get the witnesses. These were delays, and we move on to September 24th. The people are not ready.
Yeah, but why is your inability to get the witness something that should go against them?
Well, first of all, I've counted, it's 196 days for the people. We have to have some balance here. If we're going to look at only at every time we're not ready, it is the people's obligation to bring this case to in a speedy manner.
Right,
and
but
that's
if,
the difference with
they're
30-30.
saying, in 4 or 5 consecutive adjournment, we're ready, we're ready, we're ready.
And they count.
I mean, look, the delay is the defendant's friend. Everybody knows it. The guy's out.
And in the
And I think that
policy-
ultimately, when you do this kind of a 30-30 analysis, the reason it doesn't really inform it is because it doesn't take a holistic approach.
But we're not doing that. The problem is that the court below does a 30-30 analysis, and they should be a 30-20 analysis. And as far as the policy, going back to Wiggins, where he's in prison and they're trying to there is a policy behind these delays, Your Honor. It's to get a plea. And after 2.5 years and 29 times in court, they got the plea. And that's the policy here that has to end.
So you think here that there was a coercive attempt to get a plea on a violation? That's kind of a stretch, isn't it?
That's what happens
Or you're
once
saying that's business?
I'm just saying, once the misdemeanors are gone, nobody cares, except my client, who has to come into court 29 times, and at the end, they get a plea, and that's how it goes. And it shouldn't be that way. It's their obligation, and it's the obligation of the court to maintain some kind
Well,
of, thank
I
you.
understand that anyway, thank you.
Thank you very much.
Okay.